Welcome to Not My Generation, the political podcast that looks at news, events, and political happenings around the state and the country and even internationally from a generational perspective. I'm James Davenport. This is my co-host, Dr. Emily Stacy, and we have two of our favorite Rose State faculty with us today, Dr. Aaron Batchoffer and Dr. Lizzie Boger. And we are going to be talking Supreme Court, and specifically, we're going to be talking Dobbs versus Jackson Women's Health, the most recent Supreme Court ruling on the issue of abortion, which came out at the end of last week. And before we get into that, we have some other cases that Dr. Stacy wants to quickly discuss.
Yeah, I think the kind of theme of this Supreme Court is, it's giving judicial activism, right? As the kids say, it's giving, right? Giving judicial activism, and it's interesting, right? Because this is a conservative-led court, right? And so typically, these folks who err on the side of conservative ideology are constructivists. They tend to be originalist, tend to stick to the Constitution, and really revere precedent. And so, I mean, particularly Roberts, who we mentioned in the episode that we did about the leak. And so, again, it's just... There were, I think, a lot of shocking decisions. Of course, we knew that Dobbs was on
the table,
path,
right? Yeah,
we knew. But then you have some other decisions that really kind of reaffirmed how judicially active or how activist this makeup is, or this composition of the court is. So the school prayer decision, you and I kind of touched on a little bit.
So that was surprising to me, based on prior precedent, if you want to use that, or ruling. So I was very surprised that they went in the direction that they went.
Right. So this is the case where you had the football coach praying at a public high school, right? And so they were deciding whether or not he had a constitutional right to do so at the 50-yard line at this public school after the team's game. And they did so, right? They upheld his constitutional right to do so. And that, again, kind of opens up an interesting box for, I think, a lot of people who are not Christian, right? Again, we've got to think about the dynamics of this.
The court has been consistent, at least up to this point, that you allow it for one, you got to allow it for everybody, right? Which, by and large, I don't have a problem. I think that's the way you have to do this kind of thing. But yes, it opens up perhaps quite a bit of stickly issues relating to religion and in public places, especially public schools.
It's a little concerning, I think. And another that reinforced kind of the breakdown, perhaps, or the attack on the Establishment Clause would have been Carson versus Macon. This is the the court ruling in Maine, right? That had to do with the religious school, right? And state tuition being used. So Maine had been excluding, those private religious schools from receiving state tuition benefits, right? Because public funds, not all taxpayers are Christian. But again, this was another 6-3 decision where, again, they upheld that. They upheld, again, the right of those schools to receive those public funds. Interestingly, the public stand, so the New York Times did a really great summary of this and included public polling on each of these issues. And this was one where everyone in partisanship, 51% to 49%, saw it as a valid separation between church and state. Democrats, obviously, 69 to 32%. Independents, 50-50. Again, I question, and we were talking about it in relation to the Oklahoma elections, but I really do question how driven independents are in these midterm elections, and how much the Supreme Court decision that we're going to focus on today has to do with that drive.
Real quickly, that decision, I think, is actually in line with prior court decisions. The court has ruled previously that states didn't say they had to, but could, if they were offering tax credits to families for expenses going to private schools or something, they could include religious schools in that. The court has ruled that states can provide computer equipment to private schools, including private religious. So this is not far out of line, but in combination with some of these other rulings, it looks like it moves in that direction. But it's not that inconsistent with prior court rulings on that topic.
It still feels a little blurry. I mean, things feel blurrier
the court has never been
the
court has never been entirely consistent on, right? Because the Lemon test says that you can't have an entanglement between government and religion.
Right.
Well, what constitutes an entanglement?
Exactly.
The court has never clearly defined that. And so it hasn't entirely been consistent on that.
That's interesting. So there was another case. This was out of Boston, where the city of Boston had ruled that a private religious group could not. They refused to let this private group raise a Christian flag or affiliated flag in front of City Hall, but had allowed other groups to do so. This was a 9-0 decision. So again, if you're going to treat one, you got to treat them equally. But it will be interesting to see how some of these play out in actual application. Right. So I think the last one that I want to touch on before, we jump in, and please feel free. You two do not have to sit here silent while we, please feel free to jump in anytime. This is what we're about. We talk over each other all the time. But the gun rights decision, and so again, I almost got whiplash from this Supreme Court. So at certain turns, they are certainly pulling power back from the states, but then in other cases, they have empowered the states to the nth degree. And I think this one is one that is going to have reverberations. I mean, there are cases right now that are sitting before them that it's going to reverberate towards.
I thought this case in particular, it brought home to me the new law of the land when it comes to the court, which is originalism as opposed to original intent for the most conservative folks. Because, original intent would have said, okay, what would the founders have said about this issue in relation to modern circumstances? Whereas originalism, which I think is what Clarence Thomas is referring to when he said, and I quote, "All rules must be consistent with this nation's historical tradition." Right. To me, that is originalism at its worst. What did the Constitution originally say, and how does it apply to gun laws right now? Which, of course, my response would be, who cares? But
ouch.
Well,
that hurts my.
I know. I'm sorry, James.
But I mean, how do you define regulation in terms of history? I mean, again, it's a really blurry decision. So this again means that states and localities are going to have to deal with this decision kind of case by case, or as their legislatures are amending, laws, etc. And most legislatures are.
This is a nightmare for the judicial system. I mean, the pressure on lower courts is going to be astounding. Yeah.
I am interested. Please.
No, I just that statement again, consistent with this nation's historical tradition. I don't know how you expect a federal judge in Brooklyn to interpret that.
Right.
Well, usually when the Supreme Court chooses its ambiguous language that will be useful to them, they don't pick ambiguous language quite that
specific. I mean,
broad,
at
but
least
also specific. So,
right.
Yeah, that might not get them what they were wanting.
Well, the gun stocks and the bump stocks and the things have changed. We used to load guns this way, pop, and it's over. Times have changed, and it's strange to me that the burden has shifted to such a degree that apparently, I don't know.
And in this time, right? This case is coming directly out right after, the Uvalde shooting, directly after a number of racially and religiously motivated mass shootings in the United States of America. And so this decision seemingly is going to put more guns out in society should the states allow it, which a lot of them are kind of chomping at the bit, right? More trigger laws.
And doesn't this also question how the congressional folks are going to approach this issue moving forward?
Yeah.
Because to me, the way I read this, for folks who are literally loath to do anything in regard to gun limitations, this is sort of a quiet backdoor, hey, we've got your back.
Yeah.
You don't need to compromise. You don't need to come up with any new ideas.
Yeah.
I don't know.
Just a couple of days after Biden signed the first bipartisan gun reform in decades, you have the Supreme Court doing exactly what you said, kind of a, wink, wink, nudge, nudge. Yeah, it's a good time had by all.
Any other cases?
And any other cases I want to hit on? And again, the gun rights case is, I think, particularly shocking because it was challenging the New York law, and of course we just had the Buffalo shooting, so it was just the timing of it was just, like most things in America, kind of. At this point, kind of questionable. No, I don't know that I have any other major cases. Executive privilege, of course, we decided that in January, so obviously saying, and I can't get into this because I've already been scolded, but the Trump v. Thompson case ruled that Trump could not block the release, right. Of records to the House committee on January 6th, which, dear God, I'm chomping at the bit to talk to you about yesterday's surprise witness, but we will have to do that.
That will be upcoming on another podcast.
Yes,
That's right.
I've been scolded because obviously the next case that we're going to talk about is going to eat up a lot of our time. So before we get there, I do want to talk about legitimacy because this has been something that you and I have talked about on this podcast directly related to the Roe versus Wade situation, right? So I pulled a couple of polls. This one is from directly after, about a week after, May 10th, the leaked draft. Came out. 70% of registered voters said they either had, back in 2020, at the time, 70% of the voters, registered voters, said they had some, 50%, or a lot, 20% of confidence in the court. 30% said little or neither, right? So the new poll, right, from the May 10th publication, immediately after the leak, has confidence in the Supreme Court swinging by the margin of 40 points. That's ginormous. So at this point, you've got among all Americans, as opposed to just registered voters, more than 53% saying either they have no confidence in the Supreme Court, or 25% saying they only have a little. And we had CBS kind of update this. So a CBS YouGov poll from just this week, June 26th, right after we get this decision. It was a wonky weekend. Among women, huge number, right? 67 to 33 opposing, obviously, the overturning of Roe versus Wade. Nationally, 59 to 41%. So again, that's a pretty big number for nationwide, man. Independent voters, and this is where I think you are going to see the change, right? You've had independent voters that have largely been undecided up until the last minute. A lot of them we have seen in terms of turnout have kind of veered towards the Republican side of things in recent elections. The independent voters disapprove of overturning Roe versus Wade, 62 to 38%. That mirrors almost women, right? That's a huge margin. And so I wonder where these independents are going to go in the midterm election if this issue is that important to them.
That'll be the question.
Yeah.
How important, right?
Yeah.
Because you can say, yeah, I don't like this, but on my list of priorities, it's not at the top, right?
Yeah.
And so I think that will be the question come November is where does this particular issue fall in the list of priorities that voters are going to have?
Yeah.
I tend to have the sense that most people for which abortion is an issue, regardless of which side they're on, are already locked into their party alliances.
Yeah.
They're already active voters, so you're not going to see, you're only going to see some marginal movement here. And what we know about independent voters is they don't vote independently. They already,
True.
they
That's
tend
fair.
to vote one party or the other.
Yeah.
And so even with those independent voters that are committed to the issue, their alliances are already formed.
Sure.
And so I think it's going to be, anything can happen.
Sure.
And it may be that the court's opinion does in some way move this up the priority. But we haven't seen any data to reflect that yet.
Yeah.
And so that'll be the question.
I look forward to it.
Yeah.
Because I do think at least turnout will be affected, right?
Could be,
in the parties. Certainly the Democratic Party.
Yeah.
This is something that fires up folks. And you have obviously liberal white women, college educated women who this issue is very close to their heart as well, who may see changes in their party lines and may be a little bit more vocally active this time around in the midterms.
So it could certainly have an impact. We just don't know at this point to what level it would.
Sure.
Yeah.
All right. So what are we talking about?
Dobbs versus Jackson, Women's Health Organization, the Supreme Court's most recent ruling. So I have a couple of questions real quick before we jump in here. How many of us have actually read the Dobbs versus Jackson opinion?
The summary.
The summary, okay. Plus concurrences or dissents?
I read this dissent.
Okay.
Yeah.
All right, good. How many of us have read Roe v. Wade or Casey versus Planned Parenthood?
Yeah.
Okay, good. So we're all... A lot of times
Thanks for
we
the
run
poll,
into
man.
these. Hey, I just want to make sure we're all on the same page. We know where we're working from. All right. So the court says what? The court says that we're going very directly, right? We are overturning Roe v. Wade and Casey, right? And for those who don't know, Roe v. Wade really wasn't even the controlling opinion on abortion. That became Casey, which was decided in 91, 92, right around there.
Yep.
In which the court changed some of the mechanisms by which it judged whether or not a state regulation violated the constitutional right. So Casey does reaffirm Roe's central holding.
Yes.
There is some type of constitutional right to obtain an abortion. It discards Roe's kind of trimester formula.
Yes.
Uses what's called the
Undue burden
test,
I love
right? And firmly says anything pre-viability is off limits for state regulation.
Right.
Anything post-viability, to the extent it doesn't cause an undue burden, right, is permissible.
Right.
And so after that, you get a whole bunch of states testing this law, right? We've had lots of abortion cases since then in which states, primarily those that are controlled by officials who are more on the pro-life side, enacting legislation, restricting and somehow, and these cases keep coming up to the court and it either says, yes, this is permissible or no, it's not, right? The Missouri case, or Mississippi case, wanted to ban abortions after 15 weeks of gestation, right? And so what's interesting is, so the Mississippi case, the state argued that this is permissible and you should just overturn Roe v. Wade because it was bad law to begin with, and going down the road, right? The other side argued you have to strike this down because if you uphold it, you've de facto created a overturning of Roe v. Wade. So in some sense, the court was going to be overturning Roe v. Wade, whether it intended to or not, either way, right? Depending on how they were going to go. I think there was no doubt that with this majority, they were going to allow that provision. Whether or not they directly overturned Roe v. Wade, that provision was probably going to be protected, right? And so the case was. Now, Roberts, interestingly enough, argues you don't have to overturn Roe v. Wade to uphold this particular restriction. And he makes a case in his concurrent opinion that that's what we should do. We're not forced to address the merits of Roe or Casey. We should limit ourselves to the case before us, right? The majority, the 5 that ended up saying, no, we're going a different direction, disagreed. And Alito, dealing with the issue of legitimacy, right? And so Roberts is consistently concerned about that issue. Not wanting the court to get too far ahead or too far away from where the public is, right? And Roberts is making that case. Alito basically says in his response, who cares?
Right.
He says it's not up to us. What did he say? I wrote that down somewhere. But basically, we cannot allow our decisions to be affected by any extraneous influences, such as concern about the public's reaction to our work.
Or
right?
the Constitution.
Right. So he's not concerned that the public is going to do this. So there's a difference in what role concern about the court's legitimacy should play, right? And that's always been present on the court.
Sure.
Usually chief justices are concerned about. There have been some that have not been, but usually they are. I mean, that's kind of their role, is to defend that institution, because at the end of the day, the only real legitimacy that the Supreme Court has is in the public confidence of the court, right?
Absolutely.
Go back, Federalist Papers, I always like to bring them in. Alexander Hamilton says the court has no force and no will. It's only reactionary. It can't reach out and touch someone without somebody filing suit and bringing something into their process. And it has no enforcement mechanism. It must rely on the executive branch, on state governments and stuff to actually enforce its decisions.
Right.
If it loses the confidence with those other institutions or with the public at large, then its legitimacy is called into question, and people can start ignoring the court, much like Abraham Lincoln did when when Andrew Jackson, some of these others who just said, I have all the guns, stop me, right? Basically, and that's not a good situation, right, to be in. So there is this contention, right, and certainly Alito was basically saying, I don't care what the public's reaction is going to be. We're going to go this route, right? And so they do. They strike it down. They go through this whole series of discussions about how Roe v. Wade was improperly decided to begin with, and how Casey did not do anything to correct those problems, but just added to them. And now they're coming back, and they're going to overturn them. Right. So that's where we are.
That is where we are. So implications.
Well, this is originalism at its finest. I mean, the court, Clarence Thomas in particular, I think was very overt in saying anytime in the last 30 or 40 years we've used the words right to privacy, we need to go back and erase all of that, which, except, of course, the Loving decision.
Which was, uniquely omitted.
Which was interesting that was not on the list. But this is I'm hoping that this is a one-off in some ways, because Alito said in his opinion, I think, that this particular language, this concept, applies only to abortion, which was sort of, I think, an answer to Thomas, who is more or less saying, well, hell, where's Obergefell, where's Griswold, where's Lawrence?
Well, previous attempts to say, but this decision-making process or this language, we can't use it anywhere else, that's not worked. I mean, once the language is out there, the language is out there. I mean, we've already had other cases come through, and it's like, well, we said this. Well, when they said that, they said you can't do it anymore.
So Alito tries to address why this case is different than those others, right? So
he does so very poorly.
His case is these other cases didn't involve the termination of either potential human life or human life, depending on how you want to look at it, right? The Loving versus Virginia didn't involve that.
True.
Griswold didn't involve that. Obergefell didn't involve that. To Alito, and I guess to the other four that signed off on this, that's the distinguishing factor, right? Is that this case involves how we treat human life. And so the other cases didn't, therefore this is, in his, to say what you said, the one-off, right? This is what makes this different.
I mean, it's let me not be condescending. It's just very interesting that the life that we're concerned about is not perhaps the mother's life as well. There seems to be a distinct neglect over the person who's actually, housing the child. The embryo, the fetus.
Lack of regard for the quality of life or the life generally of half the population hasn't always been. In fact, it's frequently not the actual concern of the courts. I mean,
Yeah.
this is the
fair.
one that we're looking at right now.
Yeah.
But there are other examples as well. I mean,
Sure.
did the Equal Rights Amendment ever get ratified? No.
Point well taken.
And something that I bring up in class, or if any of my students are listening, they can roll their eyes. 1996 was when the last two states, of which Oklahoma was one, that enacted any marital rape law at all. It took decades for that to get on the books, because the idea of the older sort of contractual notion of marriage was, if a man and a woman got married, the man had just agreed to provide and the woman had just agreed for sexual access. And we don't think about that now. I mean, some people do, but legally that's not really how marriage is looked at. But it took a long time to get people to have a notion that wasn't actually blanket consent.
Yeah.
So I guess from a perspective more of somebody who looks more at gender than at the law, the misogyny is not new.
Yeah.
The lack of regard for the life that's already present, it's not new.
Yeah.
I mean, and when you look at some of the very serious examples of complications and problems that could come out of this kind of decision in terms of how you treat women who are pregnant and are miscarrying or have ectopic pregnancies, or women who are trying to get pregnant through IVF, those lives they're kind of what Alito does. They're not really important. You hand wave away that those are actual real lives. It's like when you look at the data on places like El Salvador, where abortion is totally illegal. It's not just that you're putting women in prison for miscarriages. Women commit suicide.
Yeah.
Like all of these very real effects, and it's hand waved away as, that was badly decided.
Yeah.
The actual impact isn't really addressed, and I don't think and they can't address it, because what would happen if they had to address the actual impact of it, of the lives that are already here?
Right. Well, I think we're going to figure that out, right? You have these states. Is the South Dakota governor getting just grilled by Martha Raddatz over the weekend, right? Where we have a complete trigger law in effect, abortion completely outlawed. Martha Raddatz is asking, okay, well, what social services are you going to provide? How is the state going to step up in terms of those children who are now going to exist that may not have before? What kind of social services are you providing, because you haven't up to this point?
Well, and what kind of social services are you going to provide to the women who were traumatized
Yeah.
by the forced birth?
You're right.
The notion, I think Coney Barrett liked to go with, well, adoption's out there, so abortion's no longer necessary. And as I read an article, and several people have mentioned this recently, so what about the 400,000 adoptable kids in foster care?
Exactly.
There's not a shortage of children to be adopted. There's a shortage perhaps of a certain type of baby to be adopted. But that again has reduced a life that's already here to as and Alito used this language in the arguments, essentially a commodity, a source of a commodity.
Yeah.
There's a supply and demand thing.
Yep.
There isn't much more dehumanizing than having a life turned into a resource. Yep. And that's what it sounds like.
Yeah, quote unquote.
But hey, somebody could adopt that baby. So you have to have it.
The domestic supply, right?
It is the domestic supply of infants.
Yep.
There is no shortage of domestic supply of children and infants in this country. There is a shortage perhaps of a certain type, and the assumption is the only women getting abortions are the ones who are supplying that, which actually flies in the face of a lot of research on who actually gets abortions. And that there's not suddenly going to be this open pipeline of little white babies being born.
Yep.
Because a lot of the middle-class white women who want abortions,
Well,
they were already living in states where it was hard to get them in their states, and so they bought a plane ticket, they got in their car, they got their abortion.
Yep.
This is how it was before Roe, and that's how it's going to be now. But strangely, you're not going to see that sudden oversupply of the children these people don't want to adopt suddenly being adopted.
Yeah.
You're not going to suddenly see more social services to help the women who have these children, because that's not the life that's most important here. It's the one that may or may not be there.
Yeah.
And I want to, so this is some of the argument that goes into these deliberations, which is, should the court be concerned with that? If you're talking about a constitutional right, should the court be considered with the after effects of supporting that or not? Or should it only be considered with what it feels the Constitution implies or delineates, right? And this has been a long-standing, running kind of debate between Supreme Court justices, legal scholars. All of this is to the extent to which the court should take into account the aftermath, right?
Yeah.
And so the court has said, we're going to let states regulate this. So now the question is, well, which states are going to do what, right? Which is not hard to figure out. There's about, I think they said about half the states, 26 states, that already have some type of trigger law or are expected to enact something very shortly to, if not outright ban abortion, restrict it even further than what they already have. So then you're going to have the remaining states who will do what? Well, some will keep whatever they have. Some will push it back in the opposite direction, make it even more available. And then you get into the question of, okay, what do we do? What do these states that have banned it do in regards to the women who decide they're going to go to another state to access abortion or access medication, right? So we have medications that they can get through the mail. Are you going to have states try to strike that down?
Where does the Commerce Clause come in?
I think that's problematic for those states. I think the Interstate Commerce Clause would, if interpreted as it has been interpreted consistently over 100 years, would prevent states from restricting that kind of activity. But
on the other hand, I think even though Alito mentioned this is not going to keep women from traveling, that this decision essentially was a big overturning of precedent. And so right now the precedent is a person that's not, say, a minor can travel across state lines to go from a place where something is not legal to something is legal. You have to let them do it. The state where it's not legal can't say, no, you can't travel.
All right.
But they've already pointed out this is different and this is special, and we're willing to overturn precedent for it. Forgive me for not having a lot of faith that they're going to back up and go, but no, okay, that precedent related to commerce, we can't overturn that one. They've already said this is a unique and special thing that's so important, overturning precedent is necessary.
Yeah, and this gets to when does precedent hold and when does it not hold, right? And so the majority's argument was we're not obligated to uphold bad precedent, right? Now, regardless of whether or not you think it was bad precedent, they believe it was, and they say we're not. Well, we've seen precedent overturned before, right? I mean, some very famous cases.
Most of the ones listed, actually, by Thomas were overturning of bad precedent.
Right. And so you can go back and track that. And actually, Alito has a long list of things in one of the footnotes detailing many cases that they overturned prior precedent on these. So, again, that goes back to whether or not you think Roe was rightly decided or not. And for the majority, obviously, they think it wasn't. There's a sizable number of people who agree with them. There's a sizable number of people who don't. Most people don't get into that argument. They just are there in these polls. They're asked, do you want Roe v. Wade overturned or not? In their minds, they're interpreting that, do you want abortion available or not? Right? That's what they're seeing. And so most people aren't getting into, and most people wouldn't get into, was it properly decided?
No, of course
right?
not.
That's not the question they're asking.
Nuanced,
But that's a different question that the court is addressing than it is, should it be accessible? And it's a different question when the court says, is this a verifiable, can we identify in the Constitution that this right exists? Now, Dr. Batchopper says, who cares, right?
Well,
who cares?
I take a broader look at it. I mean, I was a little flippant, but yes.
But there are some, obviously, on the majority, on the court, and others who think that it does matter if you can tie this to some language in the Constitution. And I think that's a little iffy. I think, as I mentioned before in one of our other podcasts, there are even very pro-choice legal scholars who said, yeah, the way Roe was constructed was not super fantastic.
The right to privacy, that was probably not the way to go.
Right. And so, and it opened the door for a direct attack like the majority did on it. So I think, though, there is a place that we can be where you can say, I agree that Roe v. Wade wasn't constructed correctly, but I'm still concerned about the aftermath of this opinion, right? and where does this lead us, right? And my concern has always been this notion of how do you enforce these bans
Right.
with any teeth that doesn't lead into some type of police state that's necessary to do so.
Right. This is fundamentally, for me, not about the act of abortion. This is about control. This is about civil liberties. This is a slippery slope into your government having immense control over what it is you can and can't do. I think Dr. Boger was maybe alluding to the Texas Attorney General, who is, going to go after the sodomy law and try to, start enforcing that.
I was surprised that, Lawrence versus Texas isn't getting more discussion.
Agreed.
And frankly, how many people know offhand what Griswold was?
Right.
Or old
Exactly.
enough to remember, or
Right.
even know somebody they can ask. What is it like to have the state determine whether or not you can get birth control?
Right.
Right.
I'm like, I have relatives that talk about counties they lived in where you couldn't get condoms, you couldn't get anything.
Yeah.
Just because the state's overwhelming interest in your birth control methods and the type of sex you're having. And so these things do have a lot of consequences. And I think the
Absolutely.
court sometimes backs off and goes, oh, no, we're only looking at this. Only other times, if you read their decisions, they do care.
Yeah, absolutely.
And I will, if I can remember what I was going to say here, I will say I do think both sides a little bit have it backwards about where Roe fits into that line of reading, right? Roe's decision was predicated on Griswold and Loving and these, right? It wasn't the foundation for those rulings, right? And so to say that overturning it automatically leads to overturning the others, to me, is getting the order backwards somewhat, right?
Well, I don't know. Are people actually arguing that overturning Roe leads to overturning them, or is it more that they see what Thomas himself said?
Right.
The thought process behind Roe is the same thought process behind these. So if this one's bad, it's like this big flag going, I'm not saying you have to go after Griswold, but you could.
It's a climate.
And it's the thought that, hey, now that you're going after this one, same-sex marriage, was decided the same way.
Yeah.
I mean, again, it's kind of like with Griswold, with Lawrence, most people don't even know the name of that case, or when it was decided, or what the impact was. And they don't think about that it's not, particularly for Lawrence, it wasn't just about members of the LGBTQ community that were affected by those laws. And so what happens now if they go after that and decide, well, it was decided for the same wrong reason? And we think about these social ones, but there are other things like, are corporations people? Where is that in the Constitution? I mean, if we're really going to go with originalism, it goes way beyond the areas that my discipline are really interested in.
Yep. I mean, bodily autonomy is hugely important, or it should be, and not just for half of the population. And as we saw in the previous 2 years, at least in relation to vaccinations, bodily autonomy is extremely important to that same, or at least
right. So you have kind of these crosswinds going on, right?
Well,
so,
actually,
and I think that's really interesting.
It led me to a question I wanted to ask here.
Please.
So, Oklahoma has incarcerated someone, a woman, for using drugs while she was pregnant, right? Okay. So clearly, bodily autonomy is something that is not an absolute in Oklahoma. So if we have laws that criminalize a woman doing something like knowingly using a substance when she's pregnant,
I know where she's going with this.
why aren't we requiring those women to get every vaccination that is required of them, or is not required, but suggested by things like OBGYNs? I mean, are we going to start, I just went to my gynecologist, it's like, and there's signs everywhere, you need these things while you're pregnant because it's in the best interest of you and your fetus.
Yes.
Are we going to start doing that? Are we going to start making sure that all of these women have not only access to, but take all of the prenatal treatments that they're supposed to
I think that's an excellent question, right? Which is, again, it goes to how far are you going to press this? And how are you going to impress this? How are you going to verify if a woman has a miscarriage that it wasn't intentionally created? And where does that lead to that? And is it presumed that it was spontaneous as
Right.
opposed to
Will she
induced.
even be eligible for the treatment?
Right.
Right.
So
Well, and when half of fertilized eggs never make it to birth,
Mm-hmm.
and it has nothing to do with women getting abortions. Sure. Overwhelming majority is they don't implant, they don't last. There's a genetic problem. I mean, it's an incredibly high number. So, what magic 8-ball are they going to use? I mean, and what are they going to start trying to legislate? Well, women don't know they're pregnant yet.
Yeah.
Well, if X, Y, or Z behavior could harm a fetus, and you're a woman of childbearing age, well, I know when I went to get surgery, they made me take a pregnancy test, even though there was no way I was pregnant. But that's in surgery, right? So there's a lot of other things that you can do. I mean, our business is going to start requiring pregnancy tests before you work on a forklift on in an unair conditioned
Right.
warehouse.
I mean, it really
Yeah.
does. For these
Yeah.
states that are trying to impose these bans, you see very quickly where this bleeds out into a whole bunch of other aspects of society that I don't think anybody right now is thinking this could lead to that. Right?
Well,
This
and
could lead us in
Somebody's
those kind of-
thinking that, sir.
Somebody's thinking
And-
it. It looks like a slippery slope now, but somebody's thinking
I
And I
mean,
think-
we're on the way to 2024. I'm sorry.
No,
Somebody is thinking this.
Well, and you're clearly, I think, historically, we will err on the side of doing little to nothing about these issues, which is what has gone on before, and it's lumped into greater sociological problems and economic problems, poverty, lack of education, and whatnot, and some of that will be subsumed underneath it. Well, you should have known you were pregnant. You should have taken. You know you have to raise this child, and why did you have sex if you knew that this was a possibility?
I mean, there's a whole TLC show about I didn't know I was pregnant.
I think
There's a whole show.
I think
there's a whole genre.
the problem the court faces when it gets into this particular issue is the fundamental question it's trying to answer is a question it's not capable of answering, right? So the whole question here, the reason you have the pro-life people and the pro-choice people is where is life existent, right? When does life exist? And when is that life imbued with these rights to life, liberty, rights, these unalienable rights? That's the question.
Right.
And the reality is none of us can answer that
Right.
particularly definitively, right? I think it's clear at some point during the pregnancy that life that's there in the unborn child is a separate life from the mother's.
21 to 24
I don't think
weeks
that
at
just
this point.
magically happens after it exits the birth canal, right? But some people do. Some people think no, that those rights aren't conferred until it's out of the womb, right? Then you've got the others at the other end who, like, as soon as it's the egg is fertilized,
Yeah, personhood.
those rights exist. I think for most people, the answer is it's somewhere in between those two, but we're not quite sure where, right?
And frankly, most
And-
people don't want to be the one to draw the line.
Right, and so we want the court to do it, but the court isn't capable of really doing that to anybody's satisfaction, right?
I would rather the court just left it alone and thought, if you would like to have an abortion, Dr. Boker, that's fine. If you would like to not have an abortion, Professor Davenport, that's fine too.
But neither side has been willing too much to do that, right? So this is the majority's argument is because we are not capable of answering that question, this is a question that should be left to the people and their elected representatives. Now, I think there's a whole problem. There's a problem with that line of reasoning, which is whatever you think the constitutional right is, you don't leave those subject to the whims of democracy, right? At least you're not supposed to. Now, we've had, listen, Dr. Stacey and I have talked about the 14th Amendment and its importance to securing these rights in a much more broad fashion than what we've had prior to it, right? But even that, it took it about 100 years to start recognizing that, right? But if you're going to say X is a constitutional right, then that inherently, to me, implies then X is not subject to the democratic process, right? My right to free speech isn't subject to whether or not most of you think I should be able to say it or not, right? My right to whatever, right? Protected from the government intruding into my home and just looking for stuff with no bounds isn't subject to whether you think it should do that, right? Those are constitutional protections that we say, no, those are off limits to democracy and to the democratic process. So, and both sides are claiming this, right? So the pro-life side is claiming that unborn child has these rights at some point in time.
Mm-hmm.
The other side is the rights fall with the mother, right?
Because for a lot of those people, the term unborn child itself is a dog whistle.
Sure.
Because at what point is that an unborn child versus 4 or 8 or 16 or 32 cells that are dividing? And that's and actually I'm glad you brought that up, because language is important here. We know
Sure.
that. I mean, that's basic
Absolutely.
intro college level. The pro-life, pro-choice. We don't say anti-life. We don't say
Right.
pro-abortion, right?
Well, some do. Yeah, I'm just saying.
You know what I mean.
Some do.
But that's the thing. When you say it's an unborn child, you've already equated.
Decided.
Right.
It's already
Right.
the language is right there. You've
Right.
already decided same rights. In fact, in this case, more rights
More, yeah.
than the woman, because the woman who's pregnant, or the person who's pregnant, whether they're a woman or not, they don't have as many rights as the unborn child until the child is born, and then suddenly the mom got back some rights.
Right.
Right? No hospital, no state can force that just given birth person from donating blood to save that offspring's life. That I mean,
And
if
on
you're
that-
Right. not an organ donor or a tissue donor, and you have a strongly held religious belief that your body is sacred and it needs to go into its grave unviolated. What state's going to pass a rule that says, well, unless you just gave birth? And then, well, clearly, you wanted to have a kid because you had sex, so you're going to just have to. No, because we hold very sacred this idea that at least in death, in most states, you do have that right. You do have that bodily autonomy. So, I think there's a good reason why they don't talk about bodily autonomy in these cases, because it's such a sticky issue.
Yeah.
Well,
Yeah, it is.
it is. You're right. And we don't confer full constitutional rights on children under the age, right? At 18, 17, in certain
19s.
cases, right, depending on the situation. But in general,
Yeah.
until you're 18, you're not perceived as having full constitutional rights. So it's clear that at some point we think there are some limited rights. Now that we do grant some to those that are children, but not their full rights, right? And so you have that distinction that is kind of lost in this discussion.
Well, and with children who don't have those full rights, how do they get those rights? Many of them go through who? Their parents.
Their parents, right? Yeah,
But not in this case.
Right.
yeah.
Yeah.
And so you have all of this stuff. And so the question becomes, well, where is the locus of decision making on this? Where should that be? Those that are, for lack, pro-choice or somewhere around there, the locus should be the individual, right? That should be who should make that. For those who are pro-life, no, the locus should not be the individual. The locus should be the state at some point, right? Where is that dividing line? There's no general agreement on that. But, and I think that's the issue that we're looking at, and that's going to play out state by state now, right? With each state pretty much answering it in a different way. And whatever constitutional right you have now is going to be subjected to what the majority of a state legislature determines it to be, right? And I don't know how comfortable I am with that.
Not at all.
Not at all.
Being someone now, listen, being someone who comes from that pro-life perspective, right? Again, I'm in general agreement that Roe was not a great jurisprudence, but I am concerned about the implications of this, because I may come from a pro-life perspective, I also come from a libertarian perspective,
sir.
which says people should be free, by and large, from too much government interference.
And I would.
And
argue
And so the
it's
question
pretty intimate.
And,
for
and
me,
what's more intimate than this in terms of
right?
government?
The question for me is, where is again, I have to be able to answer, and I can't. And this is why I think Roe and Casey probably were the best we could get in this, which is viability.
Yeah.
Right? Viability is the dividing. Is it perfect? Does everybody like it? No. But if we can be comfortable being uncomfortable with the fact that we're not going to get our way entirely on this, the viability point seems to be the best point to reconcile this. And unfortunately, those on the extremes, neither of them are satisfied with the viability
But
point.
a plurality of people.
But a plurality of people are, right? And that's where if the court wanted to maintain a perspective of legitimacy, they would have found a way,
They would have gone the Roberts.
perhaps the Roberts route or something like that, and said, we're not going to completely reverse Casey. But having said that we acknowledge states have some regulatory power, some interest. Here's where we've said that has been, and I think you go with that, right? I don't like the idea that you're going to have states on it. And this is interesting. You mentioned the gun law, the recent gun law, right? So states forever have had different gun laws, right? And okay, that seems, for some reason, that doesn't seem to bother people as much as states having different rights on abortion, or different rules regarding abortion. But they have. I mean, the court has never said in respect to guns, never said in respect to abortion, there is no regulatory interest at all by the states, right? And so we've had states who've had very different laws on both of these issues.
Right.
And it seems to me that the problem is we're not comfortable with states having laws different than what we think they should have.
Well, what is judicial activism? It's decisions that you don't like. It's
Right.
good jurisprudence when it's a decision you agree with.
That's correct,
That's
right?
right.
And so as Dr. Stacy was saying, there are people identifying this decision as judicial activism.
Right.
The majority here said no, Roe was judicial activism instead. And so I think by and large you are correct. We determine judicial activism to be whatever we don't like the court doing. And there is no firm, fixed, real
I think
application of it.
the real issue for me here, beyond, I thought it was fine the way it was. Let's just leave it alone. But that now that die has been cast, the idea that some states are already talking about going after people who have expressed an interest potentially, if they have the economic means to do this, to go to a jurisdiction where abortion
Sure.
might be available,
Right.
and that we're going to have to punish them. We're going to have to limit them. We're going to have to somehow make that not an attractive option for them.
Well,
That is,
to me, that's the gloves coming off, because I'm old enough to remember when the pro-life movement really started to move towards these incremental limitations on abortion. And they were always very careful to carve out, that this is not about the woman getting the abortion. This is about those people taking advantage of this person. The doctors, We're going to have all of these exceptions. This person has not committed the crime. It's this apparatus that's murdering unborn children. And now the gloves are off.
Yeah.
So Texas is going to let you sue somebody who performs an abortion. That's nice. But is Missouri or another state going to start incarcerating people?
Right.
That's not the same. And that's the El Salvador solution.
Right.
That you're going to put the blame right on the person who got pregnant.
Right.
And so I think there's no reason for the people who are talking about these laws to fake it anymore.
Right.
And say, oh, I'm not going to be so obviously and clearly anti-woman or anti-pregnant person. No, we're going to go back to it. You had sex. Those are the consequences.
and that seems to be the whole, the thing that bothers folks and seems to question the legitimacy of the court. There seems to be a considerable amount of evidence that the last 3 appointees to the Supreme Court lied about their position
God, yeah.
on this issue.
Yeah.
And
Well, they very
Here's-
least use some really weaselly language.
Here's my thing about that. I don't trust any of those folks involved on either side, right? I don't trust that some of those justices might have said something to get the nod. I don't trust that either of the two senators that people are talking about didn't read between the lines and know what was
please.
meant,
No doubt.
right? And so this feigned,
Yeah.
I'm shocked that they I don't buy that for a second. I think they're trying to escape any
Yeah.
kind of
Those two would-
responsibility for
Well, I'm
for
referring to
this
their
happening.
public, what they said in
Decades
front
of
of
naivety.
Congress.
Right.
That's decades of naivety there. This isn't
Yeah.
the first time that's happened.
Right.
Or the 10th.
So I think you have a court that now is decidedly going to move in this direction, right? I think that's going to put more pressure on those who are opposed to this while they have the ability to change the makeup of the court, right?
Well, and
So,
the makeup of state legislatures.
I think, I says, look, is the makeup of the Oklahoma legislature going to change drastically?
No,
No.
not drastically.
I think here's the situation. It is more common in the states to have one-party dominant legislatures
Sure.
than it is in Congress, significantly more. Most do.
Yeah.
So that's going to be a probably a decades-long
Not
process.
to the extreme
right?
that we are right now, though. Oklahoma is not. Been
Well, Oklahoma is at
this
the upper end of it,
supra
but
majority.
But a majority of
and
states have
forever.
legislatures in which
Yes,
60% of the
I'll agree
legislative
with
seats
that.
belong
Yes.
to one party.
I mean, but we're at like 80%.
We're at 80%. Yeah, so we're at the upper
Right.
end of that for
Yes.
sure. So that if there is any pushback, is if we are going to say this is going to happen in that process, that's could be a decades-long process
I mean,
for that
could be.
to change, right? So you've got to be thinking the long game on that to make
Sure.
that happen. In the meantime, you have courts both at the federal level and the state level now that are bound by kind of this decision, right? As you're assuming that they will be. And my concern goes back to what we've been talking about earlier is where does this go from here? And I'm concerned that in those states like Oklahoma that want to be super aggressive in this, it's going to be really ugly before it's not,
Yeah.
right?
Well, I think with Lawrence, after Lawrence came down, a lot of states that had sodomy laws, they refused to repeal them. They just left them on the books as unenforceable. And that's something I think, it kind of makes me think about Loving versus Virginia. When that was passed, when that was handed down, the majority of the country, in terms of polls, did not think that interracial marriage was a good idea. Okay, fast forward all these decades, and some people I'm sure are lying, but the overwhelming majority of the country doesn't really seem to think it's a big deal anymore.
Right.
So, does that mean that nobody's going to pay attention when a case to overturn Loving comes through? Or with Lawrence, you have a sea change in terms of how a lot of people view private sexual activity.
Yeah.
And what is it going to take for people to wait, what? Are you sure that was incorrectly decided? What just overarching interest does the state have in that?
Yep.
But now what the underpinnings, are they there? They're not there anymore.
Well, it's going to open up a whole can of worms is what it's going to do. And the courts are going to be answering these questions for a lot longer than perhaps had they went a different direction with this.
It also depends on how much cultural revanchism people are really aiming for here. Because it's not something we're necessarily touching on, but there's a lot of cultural revanchism here.
Yeah.
We got to take back that cultural territory.
Well, and, again, I think the court is probably out of step with public opinion on this. We've seen the polls, right?
Yeah, largely out of step.
Even within those pro-life groups, there are many who say it should be legal in certain circumstances,
Right.
at least, right? Or for a certain time period, whatever. So you have that. They're out of step with that. I don't know how they get back into step with this ruling without coming back at some point in time and saying, yeah, maybe we went the wrong direction here. And I don't see that happening with this makeup of the court.
No, you've got to expand the court.
Right. Which would be problematic.
don't know.
Problematic in getting done.
Oh, yes,
Yeah.
getting it done.
Right. Yeah. I mean, there's no problem. Technically, the mechanism is quite easy, right? Congress just says we're going to add some more
Right.
justices, right? politically,
This is gonna do it.
politically, that's going to be much more difficult to achieve.
Yeah. Final thoughts?
Well, I think the future, the stability of the court and the perception of the court will depend on how we move forward from here. Because as I said a bit earlier, I think that these last three justices clearly, to be fair, misrepresented their views on abortion, to be very fair, publicly and
Very,
privately.
yes.
And because they were appointed by a certain political group, a political ideology, perhaps we would say, there is the perception that this is already a court that's packed on one side now. Now, if they don't come for Lawrence, and if they leave Loving and Griswold and other cases, as if Alito is telling the truth for once, and he doesn't have this on, he and Thomas don't have this on their agendas, then I think perhaps over time we have the opportunity to revisit this, and maybe there's some sort of compromise, and maybe people feel better about it. But it would not surprise me at all if they come for Griswold, if they come for Lawrence, if they come for Obergefell. And Obergefell, we haven't even talked about this. That will be a tough one, because that's both pillars of the 14th Amendment. Not only due process, but equal protection.
Yeah.
Right.
Oh, man.
And that will be a booger if they go after that. But I think more importantly, we will start to see calls and maybe even action, depending on the makeup of the House of Representatives, calls to impeach some of these justices.
Yeah. Thomas is for sure questionable. Dr. Booker, final thoughts?
We started off. We were talking about what is the impact of this going to be on the November elections, and I don't really think there's any way to predict it. Because while right now it's a hot topic and lots of people are talking about it, a lot of people when they go to the polls, that's not what they're going to be thinking about unless it has directly affected them already. They're going to be thinking much more about inflation and whatever state issues they've got facing them, and so on, gas prices and so on and so forth. So, especially given that so many of the people who are going to the polls, it's not going to directly affect them, it could be very disheartening in the fall to you see polls going, we didn't really like that, and then you look at the voting, and also I noticed this before we started, a lot of the polls they've done, they've been registered voters, but those are not the people who actually show up, it's the likely voters.
Right.
And how are they going to feel, what are they going to do?
And the reality is, should it occur, a recession trumps everything else.
Sure.
It just does.
Oh, sure.
It will. That will be what's on people's mind.
God. All right, wrap us up, sir.
Good discussion. Glad
Excellent
we were
discussion.
joined by two of our favorite colleagues,
absolutely.
right?
Really?
Even more so now.
We'll try harder next time.
Yeah, I was going to say, give us a second chance, we'll change.
And hey, if you don't like this particular outcome, that's what democracy is about.
Yeah.
You need to think about who you're going to elect,
Yep.
right? And if you do like it, well, you better keep voting for people who are going to make this kind of stuff happen. That's the only thing I can say, right? Is at the end of the day, elected officials put these folks on the court. Elected officials make the laws that are going to be either very restrictive or not so restrictive. And this is a year where you can have a say in who those folks are going to be.
Amen.
Take advantage of that.
Yes, it is not a Super Bowl year, right? It's not a presidential election year, but don't sleep on the midterms, man.
That's
All
right.
politics is local, and these elections impact you way more most
The
of
only
the
vote
time.
that doesn't count is the vote that you don't cast.
That's right.
Boom.
That's
Oh,
right.
Oh, that was so good. We will leave
it
out
at
on
there.
that.
There you
My
go.
goodness. If you have any comments, questions, concerns, you can email us at
I don't know the email address. I never say
We
that.
switched
It's-
roles.
It's well, let me see if I can remember.
Can you-
Not my generation at raider.rose.edu.
Indeed.
All
All
right.
right, we'll come back with the January 6th special edition very soon.
Very soon.
Indeed. All right, well, happy 4th of July.